Thanks, Vyapak. Moving on, the first technical session is recent developments in arbitration law. May I now invite the speakers and the moderators to come on the stage, please? Mr. Cavinder, Mr. Vikram Nankani as moderators. I'll do a very brief introduction. The panelists over here, they don't need any introduction. But very briefly, Mr. Cavinder is a senior counsel, Chief Executive Officer, Napier, Singapore. Cavinder is on the governing board of International Council for Commercial Arbitration, ICCA, and Vice President of the Court of Arbitration of the Singapore International Arbitration Center, SIAC. Mr. Vikram Nankani is a senior advocate and a MCIA council member. So Cavinder and Vikram will moderate the session. We have 5 speakers. Mr. Dipen Sabharwal, he's a partner at White & Case, London. Mr. Gaurav Pachnanda, senior advocate. He's also a member of Fountain Court Chambers, London and Singapore. Mr. Mrinal Ojha, partner, Phoenix Legal, New Delhi. Mr. Naresh Thacker, partner and head, Litigation and Dispute Resolution Practice, Economic Law Practices, Mumbai. Mr. Sapna Jhangiani, partner, Clyde & Co, Singapore. Sapna was included by Who's Who Legal in their list of top 10 arbitration partners under 40 in Asia Pacific for 2018. This was very recently, so I thought I would just say it. Thank you so much. Over to Vikram and Cavinder.
Good morning, everybody. Hope that's a good substitute for a coffee or tea which you have missed. A loud hello. Today we have 5 hand-picked, just like the select Indian tea, that's what I'm not having, topics on arbitration law. The law word necessarily is not the confinement or the limit of the scope of discussion. It is per se arbitration. So the format that we propose to follow is that we have 5 panelists and we have 5 topics. Each panelist will introduce the topic, unfold the discussion with about 5 to 6 minutes time. Thereafter, we would have reactions from either the co-panelists or my co-moderator or myself if I want to. And that will take about 3 minutes of time, leaving 15 minutes, the last 15 minutes for you. So the timer is in your hands. If we are eating into your 15 minutes, tell us. Thank you very much, and that will also keep you alert. So with that, may I just introduce the 5 topics. The first one is enforcement of emergency arbitrators in India, lessons from other jurisdictions, which I will request Sapna to start off with. Then we have conflict of interest, India versus England, an interesting topic which Dipen would introduce. Then we have confidentiality, its limits, and the publication of awards by Mrinal, and areas where court must support arbitration will be dealt with by Gaurav, and finally, Naresh will handle third-party funding, what is holding India back. With that, may I request Sapna to kick off the discussion on enforcement of emergency arbitrators awards in India.
Good morning, everybody. Firstly, may I please thank the MCIA for inviting me here to speak today. It's both a pleasure and a privilege. Secondly, can I thank Justice Sikri for highlighting the key issues I wish to talk about. He certainly made my job that much easier. So as mentioned by Justice Sikri, what I'm going to talk about is the current position in India with respect to the enforceability of emergency arbitrator awards and lessons that could be learnt from other jurisdictions. The current position in India is that emergency arbitrator awards are not enforceable, and what I'm referring to specifically is foreign-seated emergency arbitrator awards under Part 2 of the Act. The position in relation to domestic arbitration awards is that if they're considered and deemed to be interim orders, then they are enforceable, but not all institutional emergency arbitrator awards are deemed to be interim orders. So the position is slightly nuanced. In India, there are instances of emergency arbitrator awards being enforced indirectly. And I use the word enforced very loosely, and Justice Sikri mentioned that there have been a couple of cases in the Bombay and Delhi High Court, which I'll talk about briefly. Now, in 2014, the 246th report of the Law Commission of India recommended that the Arbitration Act be amended so that the definition of arbitral tribunal included emergency arbitrators, such that their awards would be enforceable. And the reason for that amendment, they said, was to ensure that institutional rules such as the SIAC arbitration rules, which provide for an emergency arbitrator, are given statutory recognition in India. Nevertheless, those amendments did not find their way into the 2015 Amendment Act, neither in the bill that's currently being considered. So moving on to the two cases, in the time available, I'll deal with them just very briefly. They both concern emergency arbitrator awards issued in Singapore-seated arbitrations. In the first, HSBC Holdings and Avitel, the enforcing party sought Section 9 relief from the Bombay High Court and was granted that relief. But of course, it was a de novo review. There was no question of simply enforcing the emergency arbitrator award that had been rendered. In the later case of Raffles Design and Educomp, that was a Delhi High Court decision. Again, there was a Section 9 application filed. There was an issue in that case about whether a Section 9 application was maintainable because of the amendments and whether they were prospective or retrospective. But the court said some interesting decisions about how it would deal with a Section 9 application, and I'll take you to those in a moment. So what are the problems with the current regime? Well, I've identified two. The first I've already touched on, which is that if you seek interim relief from the court, of course there's going to be a de novo review of the merits. And this was explicitly mentioned by the court in Raffles. It said that the court will undertake a review of the substance of the interim measure, independently of the orders passed by the arbitral tribunal. The second problem is delay. If we look at the HSBC timeline, the arbitrator award was issued in May 2012, and the date of the judgment in India was in early 2014. That's a time period of 1 year, 8 months to seek interim relief. In Raffles, it was a 1 year timeline, but the judgment that was rendered in Raffles concerned whether or not the Section 9 application was maintainable. So far as I am aware, the court still has not ruled on whether or not the interim relief is granted. So let's look at the position in Singapore. In Singapore, we do have the position that was recommended in the Law Commission report. So the definition of arbitral tribunal includes emergency arbitrator, and all orders or directions issued by an arbitral tribunal are enforceable as if they were orders made by the court. So less hoops to go through. And let's look at the timelines. In both Raffles and HSBC, the enforcing parties sought orders from the Singapore High Court. In Raffles, the enforcement order was issued within 4 months. In HSBC, it took less than 3 weeks. So I've summarized a few jurisdictions where emergency arbitrator awards are enforceable. They include Singapore, Hong Kong, Australia, but there are, of course, many jurisdictions where they're not enforceable, no doubt because it's felt that they don't have the requisite degree of finality. I'll end briefly with some statistics, looking at the number of emergency arbitrator awards that have been issued by various institutions cumulatively in 2017. As we can see, the SIAC with 57 certainly has had its fair share of emergency arbitrator awards. And I understand from informal discussions with the SIAC Secretariat that the majority of those cases involved Indian parties, over 50%. Now that's not surprising because, of course, Indian parties are the top users of the SIAC. I've put some statistics there, and you can see that they are the top user by quite a wide margin. So should emergency arbitral awards be enforceable in India? Well, I don't seek to answer that question. I'm going to leave it to my esteemed co-panelists to debate and discuss with the input of the audience. But I'll leave you with one statistic. And that's from the 2015 Queen Mary White and Case Survey on International Arbitration, in which it was found that 79% of those surveyed considered the enforceability of emergency arbitrator decisions to be the most important factor influencing their choice between state courts and emergency arbitration when seeking urgent relief. Thank you very much indeed.
Thank you, Sapna. And thank you for keeping to the time. Cavinder, would you like to come in at this stage?
Yes, thank you. One of the fundamental questions when we talk about emergency arbitrator is it really better than going to court for an interim measure order? And I wanted to ask the panelists and Sapna as well, I mean, what's your experience for disputes in India? Do we really need the emergency arbitrator? Is the court that much less useful a venue? What has been the experience in India?
In my experience, Cavinder, I think for the purpose of enforcement and for the purpose of compliance with the order, I think it is literally unavoidable that you seek some kind of confirmation from court. The interesting aspect, in my view, is that instead of following the route of trying to seek the enforcement of an emergency arbitrator's emergency award or an order, it has now become easier to seek the enforcement of a confirmation order passed by a foreign court in India. So there's a Supreme Court judgment in, if I remember the name correctly, it's AFCONS, where they say that we will uphold the principle of comity of courts. And if a foreign court has upheld the order or an award of an emergency arbitrator, even if it is not from a reciprocating territory, we will enforce that interim order. So I think that has become, that's a new development which perhaps Sapna might want to follow up and have a look at.
Gaurav, does that mean that the Singapore High Court judgments enforcing the HSBC and Raffles emergency arbitrator awards may be enforceable in India?
I think so. I think potentially that route could be followed, and I think it might be easier to do that and do it very quickly rather than seeking an enforcement of the emergency arbitrators award in India, de novo. And it may actually even sort of obviate the need of review of merits of the case afresh, because that is that's what the Supreme Court said, that we will really not go into the review of the merits of the case again. If it's an interim order passed by a foreign court, we will follow the principle of comity of courts and uphold it.
That's excellent.
Yeah, but I yet to believe that we missed the bus in 2015 and did not bring in the emergency arbitrator bit. In 2018 as well, when we are looking at a further amendment which is likely to come in, and we yet are not looking at bringing in the emergency arbitrators, and the Queen Mary's report is quite clear. 79% of the users are looking for emergency arbitrator to come in, then I think that's something which should be hygiene now for us, and that is something that we should try and bring in as early as possible.
I think on that note, we'll leave that point for the audience to tell us if they have an answer. I mean, why on this earth, once you miss it in 2015, you may call it a lapse, but now again you've missed it in 2018, it borders to negligence. Why on this earth would a Babu then suddenly think that of all the recommendations made in the 246th Law Commission report, this one does not merit consideration? I hope somebody there sitting has an answer when we come back to you. Let's move on to the next one, and the next topic is conflict of interest, India versus England. No, this is not Lords. We are at the Oberoi in Delhi. Dipen.
Well, good morning. Before I discuss Lords cricket versus arbitration, just to pick up on a theme that came up, the Queen Mary Whiting Case Survey, which was relied upon the 2015 report, in the goodie bag that the MCIA has helpfully prepared, the 2018 edition of that survey is available. Lots of interesting data in there, so do find some time to go through it. This morning, the theme we are all dealing with is recent developments in arbitration law in India. Now, I'm sure a lot of you have attended plenty of arbitration conferences, and inevitably, when we discuss legal developments recently in India, a theme emerges, and that usually is finding some Supreme Court decision, some court decision, some arbitral amendment in India that we don't like. We talk about the fact that it's not pro-arbitration, and it's somehow hindering India's development as an international seat. I want to take a slightly different approach this morning. I want to spend the next 5 minutes looking at one issue, which is the conflict of interest of arbitrators and disqualification for bias, and compare and contrast the recent developments in India with another quote-unquote leading jurisdiction, England, which is where I'm based, and see and really ask your opinion at the end of it as to which of the two jurisdictions on this issue are being more internationalist and more in sync with international arbitral standards. So when it comes to conflict of interest of arbitrators and challenges for bias, the gold standard really in international arbitration is found in the IBA guidelines in the conflict of interest of arbitrators, and that was formed in 2004. It's been around for 14 years. David Rifkin, from whom you heard this morning, was on the drafting committee of these guidelines. And these guidelines are really helpful, and those of you who've served as arbitrators or arbitral counsel, I'm sure have had some opportunity to rely upon them at some point, because they provide, in a very easy, practical traffic light system, red, orange, and green, some guidelines for arbitrators when they ought to be making disclosures about potential conflicts of interest. And based upon those disclosures, judges and institutions can decide whether to disqualify arbitrators as being conflicted or not. And the contrast I want to really highlight this morning is the very differing approaches that have been taken by India and England in dealing with the IBA guidelines. So if we look at India, the 2015 amendments actually incorporated the 2015 guidelines, practically speaking, by introducing a schedule to the Arbitration Act, the 5th schedule, which contains the red and orange list from the IBA guidelines. And so effectively what India did, and perhaps in my knowledge at least, and I would welcome to be corrected, being the only country in the world to actually give so much deference to the IBA guidelines by saying these guidelines reflect the best international practice when it comes to conflict of interests. We want our judges to have access to those practical guidelines, and we are incorporating them in the Act so that if any challenge is made under Section 12, then judges and arbitrators have access to these guidelines by way of deciding whether disclosures ought to have been made and whether disqualification of an arbitrator should take place for bias or not. So that's the Indian approach. What has England done? And there has been a very interesting judgment from the Court of Appeal just 6 months ago in June, just around the time when India was playing at Lords, so just before then. And there, the case is called Halliburton and Chubb Bermuda Insurance. And in that case, Halliburton, one of the parties, was challenging the appointment of an arbitrator on the basis that the arbitrator had failed to disclose in his list of disclosures the fact that he was acting as an arbitrator in 2 other arbitrations involving the appointing party. And he had been appointed by the same party in 2 other arbitrations. And the issue was, does that failure to disclose that prior experience or connection with the party ought to disqualify him or not? And the Court of Appeal was really asked with the question, what is the standard for apparent bias when it comes to arbitral appointments? And what was fascinating was this. Lord Justice Hamblin, who was giving the judgment for the Court of Appeal in England, in 2 paragraphs referred to the IBA guidelines on conflict of interest, said that the IBA guidelines reflect best practice international arbitration, but then summarily in a sentence said, well, but that's international arbitration. The standard in England has been well established for 100 years in a line of municipal decisions, and we are going to follow the English standard. And what is the English standard? The English standard is following an objective test as to what an informed and objective observer would make of the conflict situation, rather than the test set out in the IBA guidelines, which is, in the eyes of the parties, is there a reasonable prospect of bias? And what we can have a debate about is whether the objective test is better than the subjective test, and we can have reasonable arguments about that. But to me, what was striking was the fact that in an international arbitration seated in London, these were international parties that were arbitrating under New York law seated in London, the English Court of Appeal really recognized international standards in the IBA guidelines, but really gave short shrift to that, which is in stark contrast to the Indian approach. So I finish my remarks by offering 2 questions for you to consider, and something perhaps we can come back in the allotted 15 minutes. The first one is a bit of a thought experiment. What if Halliburton and Chubb Bermuda Insurance was not a decision of the English Court of Appeal, but it was a decision of the Supreme Court of India or the Delhi High Court? Would there be articles coming out as to compliance with an internationalist approach? Because there has not been much commentary in the English journals about Halliburton and Chubb Bermuda not being very internationalist in its approach. The second question is, having heard about the different approaches that India and England have taken to this issue of conflicts, which jurisdiction has it right? India or England? Something for us to ponder about.
Thank you, Dipen. So far, 2 on 2. Both speakers adhered to the time. Cavinder, once again, would you like to?
Sure. The IBA guidelines on conflict of interest were really a negotiated position. Different countries, different jurisdictions have different positions on conflict of interest, and a consensus had to be reached and was reached by the IBA's working committee. But it still continues, as your remarks, Dipen, have demonstrated, that different jurisdictions have different conflict rules. And as commerce and international arbitration takes more and more of our attention, how sustainable is it, I wanted to ask the panelists, for different countries in international arbitration to have different conflict standards? I'm really asking, how sustainable is it to have cases like Halliburton out there?
No takers? Dipen?
Well, I mean, my view is that when it comes to international arbitration, where, as Cavinder rightly pointed out, a considerable effort has gone in to look into civil law, common law considerations and form an international standard, I think it would be folly for courts, when dealing in the context of international arbitration, to be applying domestic standards, and which is why I think the English courts got it wrong. That's my view, but again, I'm sure people will have different views on the subject.
Can I just add, sorry, I echo Dipen's views completely, but isn't there also another issue, which is, were these guidelines ever intended to be codified as law, given that they were heavily negotiated? They're soft law, they may well evolve as standards evolve, as international arbitration evolves, that has India necessarily got it right, even though it's correct to be looking at the international standards for international arbitration? Has it perhaps taken it a step too far by codifying these into law? And if you look at the first instance judgment in Halliburton, if you take the words very literally in the IBA guidelines, it can sometimes get you into problems.
Well, it's often said about the IBA guidelines on conflicts that it's not a question of whether that's correct, whether those standards are right. The point is that they exist, and the existence of it helps the process. Whether they're right or wrong, or whether there's something better, is in a way secondary.
I think in the Indian context, we have to start from a more fundamental question, that the policymakers, the legislature, have felt the need that there should be legislation in respect of rules of conflict. So that is the first step. And that is a decision which is almost always invariably in the context of the baggage of a particular nation or a culture or sort of the structure, the ecosystem that arbitration takes place in. In that context, a decision has been taken. It has been felt that there is a need for strict and clearly defined rules of conflict. It is correct that perhaps right now, straight away, they have imported the rules that are part of the IBA guidelines. It is possible that as this progresses, this experiment progresses, the rules may be again remodulated to make them more acceptable and not unnecessarily harsh. But I think as far as making it a part of statutory law in the context of both national and international arbitration seated in India, I think there is a certain degree of context to a particular jurisdiction that a legislature cannot lose sight of. And when you talk to arbitration practitioners in India, most of them would tell you that we think that they have had a positive impact.
Just to add to what Gaurav says, if I am not wrong, I think while introducing those guidelines in the statute and codifying them, one of the reasons given was that we want to introduce an objective test. Yes. And so I don't know whether there is really a conflict when the English court also set up the objective test, because it may have its own downsides in the sense that if it's an absolute test, then you are removing away the human element or not tailor-making it to a particular fact situation. If it's there in the statutes, either you're this side or the other side. So I don't know whether there's really a conflict, and that could be probably another debate which can spin out of this topic. Let's move on to the next one. We've been taught from times immemorial that one of the significance of arbitration is confidentiality. But on the other hand, we are losing a lot, especially in terms of the knowledge bank, the awards that are made, and whether we can derive any utility from those awards. What is the right balance to be struck between confidentiality and, let's say, publication of awards? Mrinal will take up this topic and present his...
Good morning, everyone, and thanks, Vikram. I think that was pretty much what I was going to say for the entirety of the talk, and leave it at that. And we have a contraption here that's working like a reverse teleprompter, because everything is coming up. Instead of telling you what you should say, it's telling you what you should not have said. So confidentiality, even when we were studying law as students and throughout our careers as lawyers in the field, we've always been told that what's the advantage of arbitration? Confidentiality is key. Now, reading it again and again, I think we started believing it is true. But frankly, we've never had clients coming in saying, I want to arbitrate because it's going to keep things confidential. The biggest drivers for arbitration seem to be other factors, such as the speed with which the matters will get resolved, the cost of, if it's a compressed timeline, then it's obviously going to be relatively inexpensive as opposed to years of litigation. There will be finality of the award. Of course, there are challenge processes, etc., but they are narrow and they're getting narrower still. But we've not really come across very many people saying that, I want to arbitrate because it's confidential. And Dipen will be very happy to know that after Sapna, I'm also going to refer to the White and Case study. And he'll be happier to know that I'll quote from the 2018 study, where on confidentiality, in summary, it said, clearly then, confidentiality remains a matter of some degree of importance for many, if not most, in-house counsel. This is, however, tempered by the qualification that, as discussed in the 2010 survey, confidentiality is not of itself the biggest driver behind the choice of arbitration by the parties who use it. So since the 2010 survey, in fact, that figure had been consistently dropping. Not very many people are assigning that much importance as maybe to emergency arbitrators being one of the features within arbitration. Now, there are a few more factors, at least in the Indian context, that do signify that confidentiality is not what it's cracked up to be. One is that when you're seeking interim relief, you're filing a Section 9, you're quoting chapter and verse about the dispute before a court. That's going to come out in a decision. People are not really so cagey about what is the dispute between them. If they're filing a Section 11 application for the appointment of an arbitrator, likewise, there is a tendency, instead of just saying, here is the arbitration clause and here is what's the dispute broadly and please appoint the arbitrator, there is a tendency to shove in the entirety of the kind of dispute that the parties are facing, as if they're seeking not just an appointment, but really a decision by the court, besides the appointment of the arbitrator. And then comes the challenge process. Whether it's a domestic arbitration in 34 and international commercial arbitration, when you're taking the objections in a 48, it just comes out in any case. You're filing the award, you want it executed. At least I have not come across clients saying that we want the court's records sealed because we do not want this getting public. And then there is a subsequent court decision coming from that, where again your award is out in the public in any case. Everyone knows that you've arbitrated. So what part do people really want confidential? Is it the factum of arbitration itself that parties are arbitrating? Surely not. Many companies who are listed entities have reporting obligations. They in any case have to tell people that they're being sued. Now, whether that's in a confidential arbitration process or whether that's in a litigation, a separate thing, but the factum of arbitration is not all that crucial to protect with confidentiality. I might be saying something controversial and I'm open to criticism on this, but that's what I believe, at least for now, the next few minutes. Next, the process of arbitration itself. Many people confuse that process being private with confidentiality. And I think what the process being private is concerned with is that we will give you privacy. Strangers will not walk into the arbitration room and say that I want to hear what's going on in this arbitration because there's nothing confidential about it. It's a separate thing. It's accepted that that process can be protected. It can be away from the public glare. Maybe not in the context of bilateral investment treaty arbitrations or other investment treaty arbitrations, where there's a public interest in some transparency on even the process. And then that's the award itself. The award itself being confidential, like I said, it does come out in the open in any case if there's a challenge process. Now, why I think confidentiality in any case, which was a myth, is something that we can sacrifice is because it's coming at a cost of the development of the commercial law. There are newer kind of agreements, newer kind of problems in interpreting them that are coming about, and there is no guidance, and there is going to be decreasing guidance in decades to come in how you're going to actually resolve those disputes. We have clients in certain sectors, like the reinsurance sector, who will face a situation where they're having two arbitrations on similar points, and they run the risk of inconsistent decisions coming about. The inconsistency is not a ground on which we can get awards set aside. But more importantly, neither of those tribunals have the ability to look into case law because there is none. They don't have the ability to look into past arbitrations that have dealt with that issue because those are not published widely. There are some institutional arbitrations that are publishing awards. They redact them and publish them. And I think whether the MCIA should go down that route is something of an open question. MCIA does have detailed provisions with respect to confidentiality, and they're quite sophisticated. There's a proposed amendment in the Act now in 42A, where confidentiality is being statutorily recognized because it's not otherwise statutorily recognized, but it doesn't seem to give the option of to the parties to opt out of that. It does not say unless parties otherwise agree. It just says that the award will be confidential, the process will be confidential, save for implementation and enforcement purposes. So I think confidentiality is not what it's cracked up to be. I think not publishing awards, we are missing a trick, which we'll realize decades down when we have literally no case law to look at. And I think it's a problem of how do we publish is a separate problem. That is something I think worth discussing, not whether we publish or not. Thank you.
Thanks, Mrinal. Many great inventions are born out of radical thinking, so don't sound defeated. Cavinder?
Just to share from a Singapore perspective and practicing in the Singapore courts, it's every enforcement action gets sealed at the first instance of any party asking it. The court, even before the application is heard, will administratively seal the court file and immediately anonymize the party's names. So whenever if you have the chance to be in the Singapore Supreme Court and you see the law list, you will inevitably see ABX versus Z34, and you'll know that's an enforcement arbitration case with the names anonymized. One of the judges being, I think he was entertaining himself, wrote his decision on the enforcement, the setting aside case, using the party's names and characters all from The Lord of the Rings, just to perhaps entertain himself. But my question for the panel is this. We know the benefits of publishing awards, but why should a party care? I mean, if parties' consent to the publication of the award is necessary, but why should a party care at all? If they want it confidential, and should they be criticized, should they be encouraged to think about the bigger picture of development of the law and so on, when really they just want their one dispute resolved? Should they care?
So, Cavinder, if I again take a comparative perspective on this, the appropriately named Lord Justice Judge, who's a senior judge in the English judiciary, gave a very remarkable speech about 18 months ago on this very subject. The number of commercial arbitrations in London between the LCIA, the London Maritime Association, and ad hoc arbitrations now far exceed the number of cases going before the London Commercial Court, the High Court. And Lord Justice Judge made the point that if commercial parties want to have certainty in law and they want to know their commercial transactions, what exactly they're doing, perhaps it's in their best interest to have publication of awards, because substantial jurisprudence is now being developed in those awards rather than court judgments. And therefore, even though it may not be in their short-term interest, it's going to be in their long-term interest. And again, there are some very strong views on both sides on the subject, but it's an interesting perspective.
I think similar views were expressed by Lord Chancellor in March of 2016, if I'm not mistaken. Yeah, sorry, Naresh.
No, so I personally also believe that if you want uniformity in the decision-making process, it's very important that, these decisions are made public. But, I just had one comment on what you mentioned about how the Singapore courts actually deal with any challenge or any other proceeding which comes to court. I mean, in India, you walk into any five-star and the names are very proudly displayed on who's arbitrating against whom. So, when we talk about confidentiality in arbitration, I really don't understand, what we are really talking about, because every five-star that you enter into, you'll find an arbitration going. For all you know, today, somewhere around in Oberoi's, you may have an arbitration which is currently on, which will very proudly say, who's arbitrating against whom. So it begins, to my mind, the stage at which you begin your arbitration. Really, the confidentiality should begin at that stage and not, just at the stage where either the publishing of the award is concerned or a challenge to an award, really.
Well, you might reach a stage where you walk into the five-star hotel and you see a sign that says Frodo Baggins versus...
Well, perhaps,
why not?
Perhaps, taking the Indian example a bit forward, perhaps, and this is just food for thought, perhaps the way forward could be that arbitration should be confidential, as strictly enforced as it is today in Singapore, but it should be for the asking, in the sense that unless and until a party makes a request that it should be so treated, it should be out in the open. The award should be out in the open for others to take benefit of, which perhaps then leaves it open for parties that seriously need the umbrella of confidentiality to make that request and have it for the asking. But if they don't really need it, then a larger purpose of certainty of the law is served, I think.
If all awards are redacted before being published, would it matter?
Right. I think the point which Mrinal started off with is this, that if ultimately the cat is going to come out of the bag, why the fuss? But at the same time, in fairness, it's more an India-specific question, because 8 out of 10 arbitrations land up in court. look at those jurisdictions where the percentage of such challenges is minimal and the compliance rate is very high. Confidentiality does matter in those jurisdictions, and that is something that I will leave for the later debate. May I now move on to the next topic, which is contrary to the general mantra that we normally hear, that keep the courts away, we don't want them to interfere with arbitration, but there are necessarily times and exception situations when we want the court to assist arbitration. Gaurav will deal with this topic.
Thank you. I wanted to very briefly introduce to all of you a very interesting development of law in India in the context of enforcement of interim orders passed by arbitral tribunals. And the concept is really the development of the concept of contempt to an arbitral tribunal as a method to prevent breach of interim orders passed by arbitral tribunals. So in India, we have grappled, ever since the enactment of the Arbitration and Conciliation Act in 1996, we have grappled with the problems associated with enforcement of an interim order, interim measure of protection ordered by a tribunal. As most of you would know, like nearly all jurisdictions that follow the UNCITRAL model, in India you can seek an interim order of protection from courts under Section 9, and then you have nearly similar powers vested in the tribunal to make interim orders of protection. Early on, way back in 1999, the Supreme Court noticed that there is a fundamental difference between the enforceability of the two orders, whereas a court order will be enforceable through coercive process that courts can resort to. The arbitral tribunal's order is literally like a piece of paper. If a party decides to breach it, then there might be ultimately some kind of sanction in the form of an award for breach of an interim order. But at that stage, the party that has the benefit of an interim protective order can't do much about it. As a result of this, what we saw in nearly a decade and a half now is that the bulk of applications for interim protections went to court. One of the underlying purposes and objectives of having an efficient arbitration law in India was that we have a court system that is clogged anyway, and we wanted to move commercial litigation to arbitration. But when Section 9 applications started coming back to court in a big way, it developed as a new, completely sort of new species of litigation that all of us senior advocates were benefiting from. You saw a bulk of Section 9 applications in court, and as Sapna pointed out, on an average in court for about 8 months to 1 year, just to get an interim relief. An alternative effort was made by several parties, and I'm not taking you through all the decisions, of seeking confirmation orders, in the sense that you go to an arbitral tribunal, seek an order of interim protection, and then go to court to seek a Section 9 order to confirm it, so that at least it is enforceable, and the party that is against which the order has been passed is bound to follow it. That experiment was not very successful. Majority of high courts in the country felt that there is some degree of election between remedies when you choose to seek an interim order from a tribunal as opposed to a court. And if you've gone to a tribunal, then the court really doesn't have much to do with it, and it will not confirm that order. It is in the context of one such petition before the Delhi High Court that a very innovative interpretation was made of Section 27 of the Indian Arbitration Act. Section 27 really deals with court assistance in getting witnesses before court, before the arbitral tribunal. So you can seek summoning orders through court. And in the last subsection, there was a reference that should a party not follow the directions of the tribunal or interrupt or be uncooperative during recording of evidence, and then there is an expression, or guilty of any contempt of the arbitral tribunal during conduct of arbitral proceedings, the tribunal can make a representation to the court to take appropriate steps. The Delhi High Court interpreted this provision in the context of the underlying objective of arbitration law in India and said that in the case of a breach of an enforcement, in the case of a breach of an interim order of protection passed by an arbitral tribunal, the tribunal could make a representation to court to initiate contempt of an arbitral tribunal proceedings against the party that has breached the interim order. This case, Sri Krishnan versus Anand, was, it evoked mixed response. A lot of the, somebody asked me in Singapore a few weeks ago, was this followed? Did parties start resorting to these applications? Actually, a lot of us were very skeptical, and some of us were quite waiting for this order of this judgment of Delhi High Court to be distinguished or overturned. As a matter of fact, Bombay High Court in Alka Chandeshwar's case distinguished it, in fact disagreed with it, and said that this provision that the Delhi High Court has referred to is a provision only for the purpose of summoning of witnesses, and you really cannot use this provision for the purpose of enforcement of an interim protective order passed by the tribunal. But in 2017, Alka Chandeshwar's case reached the Supreme Court, and the Supreme Court has confirmed the view taken by Delhi High Court and has said that in the case of a breach of an interim protective order passed by an arbitral tribunal, it is possible for the tribunal to make a representation to court and initiate proceedings for contempt towards an arbitral tribunal. Very strong development. I think the natural consequence of this judgment of the Supreme Court is that the arbitral tribunal's orders now have somewhat similar degree of sanction as associated with court orders, and in practice, by virtue of this decision, it is less likely for a party that has suffered an interim order from the arbitral tribunal to breach it with impunity. There is, however, a new development that has taken place following, in fact, not really following, but expanding the scope of interim orders passed by arbitral tribunals based on the Law Commission's, based on the recommendation of the committee that advised on the amendments to the Arbitration Act. We now have, after the 2015 amendment, subsection 17(2) of the Arbitration Act has been amended, which basically, as a result of that amendment, now says that an order passed by an arbitral tribunal under section 17 for interim protection will be deemed to be an order passed by court for all purposes and will be enforceable by courts. Correct me if I'm wrong, but I haven't really come across many jurisdictions where interim orders passed by arbitral tribunals would be enforceable as orders passed by courts on their own. And I think this is a development which perhaps, in my view, is unique to India and is, I think, very arbitration friendly. It has the potential of substantially reducing applications for interim protection going to court. It also has the potential of making sure that the arbitral tribunal itself is the master of the entire dispute, and there is no need for you to really run to court except when it reaches the stage of enforcement. There was some confusion immediately after the amendment as to what do you really mean by deemed to be an order of court for all purposes. Would the arbitral tribunal have the power to initiate some kind of contempt proceedings on its own? This problem was recently clarified by the Bombay High Court in Sundaram Finance, where the Bombay High Court has said that you will pretty much follow the same procedure that was discussed by the Delhi High Court in Sri Krishnan's case, that in the case of a breach of an interim protective order by an arbitral tribunal, you will go to a tribunal and the tribunal will consider your application and then perhaps make a representation to court to initiate contempt proceedings or proceedings in the nature of contempt in some form or the other. And therefore, there is a two-layer scrutiny. It's not as if you straight away start contempt proceedings. The tribunal will have to be satisfied that this is a genuine case of breach, and then the proceedings will have to be initiated before the court, which will then take action based on contempt. there is some criticism of this development, particularly Sri Krishan's case and Alka Chandeshwar's case, based on the argument that in Raffles' design, the case that Sapna referred to earlier, Delhi High Court didn't really follow the principle of election between remedies. Delhi High Court did confirm by way of a court injunction, an order passed by the emergency arbitrator. But as Sapna's presentation clarified, that's illusory in the sense that what Delhi High Court has held in Raffles' case is that they are not really confirming the order of the emergency arbitrator. They are really looking at it de novo, and they're just, the Delhi High Court has said, we are just saying that just because there is an emergency arbitrator, we are not prevented from exercising jurisdiction and looking at the dispute afresh and passing an order under Section 9 of interim protection if the party is otherwise entitled to do so. In my view, this is a very interesting development. There is very little jurisprudence and very little fact-based examples to analyze as to what impact it is going to have in terms of seeking interim protective orders in arbitrations. But intuitively, as an arbitration practitioner, I think that this is a pro-arbitration development which strengthens arbitrations seated in India. Thank you.
Thanks, Gaurav. Quick word, first from Cavinder and then from Dipen. Have you heard something like this in your jurisdictions?
I have not heard of this development before, and the first thought that came to my mind is a comment I'll make and invite comments on it. The way the provision seems to be structured, the tribunal has to approach the court to seek the court's assistance.
That is correct.
And certainly I think there would be many international tribunals that would find that creates a discomfort for them, because right or wrong, their approach would be seen as taking a position against one party, and that might come close to descending into the arena and compromise their independence for the rest of the proceedings. And I wonder whether that comment is right or wrong. It was a first reaction.
It is by this stage, under the scheme that Indian law has now created, both by judgment and by legislation, by this stage the tribunal would be called upon to make a representation, really. The tribunal would have passed an interim order in favor of one of the parties, which would have been breached by the other party. And at that stage, to make a representation saying, I did pass an order in favor of one party, and the other party before me is not following, and I need your help in enforcing the order, I'm doubtful. In the Indian, I don't think it seems counterintuitive to me to believe that that would be similar to the tribunal taking sides, I think.
Yeah, it is though more than just saying that it's not been complied. It's going to the court for the purpose of getting something fairly serious, an order that this is contempt of court. And I guess the devil will always be in the details, but that raises a red flag in my mind. I wonder what others think.
I should just add one point to this in the Indian context. I mean, we all see a lot of contempt applications in court. Hardly anybody goes to jail. So I think what happens as a result of this is that you will have the court cracking its whip and making sure that the order of the tribunal is complied. So in reality, I don't see too much in terms of harsh consequences.
No, I share Cavinder's concern in terms of the tribunal entering the arena as such and the discomfort that may cause. I'm certainly not aware of such an option being available to tribunals in England or tribunals making such applications. It is open to parties to actually approach the courts and seek contempt for non-compliance with tribunal orders, but certainly unusual for tribunals entering the arena as such.
It does seem to be a sui generis situation in India.
Yeah.
Whether it's good or bad, I don't know. It may be a result of judicial surgery in Alka Chandeshwar's case. But let's move on to the last topic, which probably would be discussed in every second conference of this kind, third-party funding. But what is holding India back is the question. Naresh will take the lead on this.
Thanks, Vikram, and good morning to all of you. Yes, this is a topic which Vikram rightly puts it, it's something which is discussed in every conference that one goes to. And clearly from an India perspective, there are a lot of funders who are looking in. There are a lot of, in fact, when I speak with friends out of India, they ask this question that, what is it that, that is keeping India really back insofar as third-party funding is concerned? And I would really put it this way, that it's more of a matter of perspective than anything else. Because if you look around and hunt for the law which actually prohibits a third-party funding, you will find none. There is nothing within the law that actually prohibits third-party funding. Interestingly, what you will find is that if you go back in point in time, as far back as in 1874, there was a decision of the Privy Council, which was a decision of Chidambara Chetty versus, I'm forgetting the second name, sorry, it's Renga Shetty. This Chidambara Chetty versus Renga Shetty. In this decision, the Privy Council actually looked at decisions as far back as 1839 and then followed it up all the way up to 1874. Looked at all the decisions which were, positive or negative, either in favor of a situation of a third-party funding or against it, and actually held that a third-party funding, which is nothing but a arrangement between two private parties, which is a contractual arrangement, which would come under the Indian Contract Act 1872, is actually not illegal in that sense. What really comes forth and what really comes out of this entire debate is the debate on two concepts which third-party funding really touches upon, that being of maintenance and champati, and a third concept really of barratry, which is nothing but a serial maintenance of suit, as popularly in the Wild Wild West known as chasing the ambulance, really. Those two concepts, as far back as in 1874, the Privy Council actually held that they were, while in England, even at that point in time, both these concepts were actually treated as illegal. In the Indian context, they said that it's very different. It's not to be treated as illegal, but it yet has to cross the threshold of public policy. And that threshold of public policy that we speak of actually finds mention also within the Contract Act. If you look at Section 23, it talks of a contract meeting with the threshold of public policy. Following up on the 1874 decision was an 1876 decision. Again of the Privy Council. In that decision, the Privy Council looked at and reconsidered the decision in Chidambara Chetty and came to the same conclusion. So these two decisions thereafter possibly became the landmark decisions which were followed to a great extent. In 1949, there was a decision of the Bombay High Court in Lal Swaroop versus the Court of Wards, where the Bombay High Court took it a little further, and the Bombay High Court actually said that not only is this permissible, but since the funder is putting in money and taking risks, they can also take benefits of an exceptional nature. Now, if that is so, then what stops really a third-party funder from keeping a step away from India? 1954, there was a decision of the Bombay High Court again, and which went all the way up to the Supreme Court. In that, the decision of the Supreme Court is 1954. The decision of the Bombay High Court was a little earlier. This was in the case of a senior advocate who had indulged in champati, and the question which arose before the Supreme Court was really the champatuous treatment of the entire case vis-a-vis the senior advocate. While considering that position, the Supreme Court in para 11 of that decision clearly said that if this was a position between two private parties, so if this was a contractual arrangement between two private parties, it would be allowed, and why not? But since this is between a lawyer and the client, the issues of conflict arise, and therefore, if you go by the rules of the Bar Council, this is something which is not allowed. And therefore, to my mind, the issue of third-party funding has to be looked at from two different prisms. One is contractual arrangement between two private parties, and the other is what happens when a lawyer actually enters this arena. To my mind, when a lawyer, when he enters the arena, it is clearly a case of champati. It is clearly a case where this is frowned upon. It is not permissible in law, because if you look at the Bar Council rules, beginning from Rule 9, where, which provides that an advocate should not have any pecuniary interest in the case that he is handling, to 18, to Rule 20, 21, 22, and I can see, the time running against me, but, just to complete all the provisions there. So you have 22 and then finally 32, Rule 32. If you were to bring all these rules together and to read them together, you'll find that it is something which disallows a lawyer from partaking of a transaction of this nature. But all in all, I do believe that a third-party funding, if it comes in between two private parties, then that is something which is not illegal. It is, there is no law against it, and it's really a matter of perception which keeps this back. One last point on this. When I said that there is no law which prohibits third-party funding, there is a law which, if you were to consider in the proper light, someone may argue to say that it actually allows third-party funding. If you look at CPC, Rule 25, Sub-Rule 3, Order 25, actually, Order 25, Rule 3, if you were to look at that provision, it is a provision for the courts to order for costs. And Rule 3, there has been amendments which have been brought by various states in the country. So you have Maharashtra, I think it's Andhra Pradesh. I'm forgetting the third state which is also brought in the law. But these three states have actually brought in law which says that if you were to, if you have actually brought in a third-party funder, then you should disclose the name of the person who's actually bringing in the third-party funding, and you should disclose the nature of the funding. So if that is so, then it clearly presupposes that third-party funding is actually allowed in the country. So I do believe that, this is again, just to sum it up, not illegal, but if a lawyer was to indulge in this, it would certainly be treated as illegal. Thank you.
Thanks, Naresh. Since we are run out of time, instead of inviting the co-panelists here to have a bash on this, we'll go down straight to the floor and invite questions on any of the 5 topics that I can see a couple of hands being already raised before the buzzer time.
Thank you. First of all, thank you for the excellent presentations. I'll be quick. My name's Robert Hunter. Almost all the topics, if not all the topics today, touch on one underlying premise, that arbitration should be analogous to court litigation. They don't always express the same view, so the confidentiality in Singapore does not take that assumption. Do we want to run that route? The obvious example is the comment about the need for precedent. In a common law system, that's necessary for stare decisis. But if we take the route that arbitration should feed that, sooner or later we're going to end up with a lot more supervision of arbitration to make it more or less directly analogous to the controls of court litigation in selection of judges, appeal, and so on. My own view is that arbitration is profoundly different to litigation. It shares a judicial basis, but it lacks a lot of its aspects, like the public administration of justice. It has other aspects. You can select your partner. You can consent at the time of arbitration agreement to matters like confidentiality. I just wonder whether it's right just to assume that all these other trappings of litigation should apply to commercial arbitration.
Fair point, Robert. I suppose, in a sense, it's like East and West, they'll never meet, but somewhere the shadows clash. So it's inevitable, but yes, a fair point that these two have to be kept distinct. Yeah, sorry, we have one more hand going up there.
Hi, I'm Satinder Kapoor from Satinder Kapoor and Associates. And I have a point to make on the conflict of interest and a challenge to an arbitrator, which I had been very unfortunate to make before the ICC court about 10 years back against a very senior counsel from the Indian Supreme Court. Now, I believe ICC rules seem to be like a gold standard for institutional arbitration rules. And a lot of these new institutions draw from these rules. But after a very hectic challenge, and I had Whiten case on the opposite side, by the way, my challenge was rejected, and no reasons were given by the ICC court. It seems there is no provision in the rules of ICC, arbitration rules, to give any reasons for rejection of a challenge to an arbitration application. And this can be highly frustrating because it would also lead, in any case, to some kind of a bias in the mind of the arbitrator whose challenge has failed, and more so without any reasons being given. So I would like to make this point that at least some reasons should be given for rejection of a challenge.
Cavinder, anything from the SIAC experience?
Well,
Sorry, I can see.
I think the provision of reasons in that situation is necessary. I think if not, the cloud remains, especially when there's a dismissal. And if the challenge is upheld, I think the arbitrator deserves to know what he's done wrong.
I could see Christopher Lau putting his hand up. Sorry, can someone provide the microphone, please?
I've actually recently stepped down from the ICC court. I've been on a court member for 2 terms now. And what I can say is the ICC court recognizes that it is necessary to give reasons, and it now does. Okay?
Yeah. Thanks, God.
I'm Kamaru Mittal from the Indian Navy. This is on the issue of confidentiality when we are talking of arbitration proceedings. Are they really required is an issue. Because when you look at it in the Indian scenario, large chunk of infrastructure industry whom we are dealing with, and particularly when you are looking at public interest projects which are there, at the time of tendering, you want to know the litigation history of the party or the bidders which are there. Now, if litigation history, if this is confidential and it is not provided in the litigation history, you don't know, and you don't have those details available at the time of the tender, which is there. So, in effect, this confidentiality, how does it help in the public interest is something which I'd like to know.
So you're not in favor of confidentiality?
I'm not in favor of confidentiality at all, which is there. Because as brought out by various speakers all along, it actually doesn't remain confidential, and it just remains...
you have at least one fan with you.
The stop sign had come, and I could only say we agree. So that would be pretty simple. But I think if parties want confidentiality, they can shift to mediation. And let's give a leg up to mediation then. That's one way to look at it.
I'm sure Robert would be nodding his head vigorously. Sorry. Yes, someone there? Oh, you want to give priority? Good, thank you.
Thank you. Thank you for the excellent panel. I think we heard the whole spectrum, right, from confidentiality to enforcement and funding. My question was more on the funding side, and we sort of know in other parts of the developed world there are businesses which thrive on doing litigation funding. I'm more curious to understand from our panelists, from their experience in the UK and the Singapore market particularly, about how, if they have seen any instances of arbitration funding from those markets, and if there are some key learnings for us to look at.
Oh yes, you will get wealth of information from the panelists here, but I would then say that let's take it offline and you can share your experiences with them. Absolute last question, because I have been shown red cards, red eyes, red everything.
Thank you very much. My name is Nitin, I'm from Malaysia. It's just on the question of confidentiality. It's not a question, but I just wanted to share my experience. In a particular series of arbitrations, 5 in question, 3 of which I was involved in, 2 of which there were some Singaporean solicitors handling, the counterparty was a particular monopoly buyer of a certain industry. I won't mention who it is because that'll disclose what the nature of the thing was. You had 5 arbitrations dealing with essentially the same point on almost exactly the same form of contract, and you had 5 different outcomes. In my own 3 cases, in one case we got 50% of what we claimed, in one case we got 0% of what we claimed, and in one case we got 200% of what we claimed. So, and when I was speaking to the general counsel, who happened to be my junior, he was pulling his hair out and saying, how do I advise my board what this bloody contract means? Because every single time I'm re-arguing the case, and these are all eminent panels who've come to completely different conclusions. That's the problem, I think, with confidentiality in arbitrations. When you have standard form contracts and you're getting different outcomes in each standard form, how does a general counsel for any party advise his client what it means? Because it's never tested in court. Thank you.
I think with 200%, you should stick to that contract.
Yeah.
That's,
you hedged your risks well.
No, I think we are all presupposing the issue of confidentiality in the context of common law, but what happens in a civil law country where there's no concept of precedent? I think on that note, we will have to end. Enough of food for thought, now the real food. Thank you.
I thank the moderators and the speakers for such an insightful session. Thank you.